Okay.
All right, Mr. People versus Lanto.
Your Honor, James Kazicki, I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments because I'm not familiar with the issues in it. And I'm just asking the court if I can withdraw.
All right. Then, Mr. Lanto, then I can appoint a different court-appointed attorney.
Well, I just want to clarify and make sure I'm going to be able to speak for myself in the court. I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is to be left alone. So that's first and foremost. And then as far as an audio only recording, I was told that there's an objection to the audio only recording. And I'd like to know, I don't feel safe without a recording. So is there any reasonable objection?
Well, first off, you can't record in the courts of law. They're already, if you'd like a transcript, everything is already being recorded by my court recorder. And I can assure you that there's no, the recording device is on and it records, and that's what she does. She records everything. So if you'd like a transcript of that after the proceedings, you're more than welcome to order a transcript. So
I've been told that before, and then when it comes to getting the transcripts, I still am waiting for the transcripts when I was told that in the past. So, well, like I said, I don't feel safe without a report.
I know that you're not talking about the 23rd District Court, because I know if you've ordered a transcript from my court, those are always forthcoming. I've never had to deny anybody a transcript. So, well, if that happened to you in another court, then I suggest that you call the State Bar of Michigan and report that court, because obviously they're not doing things correctly.
Well, yeah, I have no desire to do that. All I want is to have fair and meaningful hearings. And well, I mean, first off, I'd simply just like to be left alone. But other than that, I mean, to get fair and
I get that, but obviously you had an interaction with somebody where they are alleging that because today's date and time set for the arraignment. So I want to make sure that you understand. I need the phone. On the date and time in question, it is alleged that, because first let me do the arraignment part, because I need to let you know what exactly you're being charged with. All right. So you say you want to be left alone, but they're claiming that there was an interaction. Now, first off, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney if you got a 411 will be appointed to you by the court at public expense. Now, it is alleged that on November the 17th of 2022, while in the city of Taylor, that you violated City Ordinance 32-31, which is a charge commonly known as interfering with the police authority. That is a misdemeanor punishable by 93 days in jail and or up to $500 in fines. So, as to that charge, how do you plead? Guilty or not guilty?
Well, first, can I just make a few clarifications?
I'm going to caution you that anything you say can and will be used against you. So
I understand.
As to guilty or not guilty, that's just the only question I'm asking right now.
Well, in order to say guilty or not guilty,
or you can stand mute, which means I'm not saying anything, and then I will enter a plea of not guilty for you, so that you don't have to say anything, and it automatically goes to not guilty. So are you pleading guilty, not guilty, or standing mute?
Well, before I make a plea, you stated that I have the right to be informed of the cause and nature of the charges, correct?
Right, which is what I just told you. I just told you what the charge was.
Okay, and you're stating that it's based on an interaction. So my guess is that you have no firsthand knowledge of anything that happened.
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with. They have charged you with a violation of City Ordinance 32-31. And that ordinance is commonly known as, by name, as interfering with police authority. I'm not putting any allegations. I'm not stating any facts. I'm merely stating what has happened to get this case into my courtroom. That's it.
You sound awfully fair to this point, and I certainly appreciate that. Because, yeah, and just to be specific, it's not the people of the city of Taylor, it's David Jones, and then I don't know the name of the prosecutor, and I just want to make sure that the prosecutor is aware of, Section 241, Section 242, Title 18, deprivation of rights under color of law. I want to know if they're aware of that.
Well, first off, that's a separate, what you're talking about is civil type cases.
Well, it's also criminal.
So what I'm saying is, in this matter, the matter that is before me, okay, is a misdemeanor matter where it is alleged that you violated an ordinance of the city of Taylor. The people of the city of Taylor, through their attorney, have acted to bring a case against you. So the only thing I can do right now is ask you, are you pleading guilty, not guilty, or standing mute?
Can I have the name of that prosecutor that's bringing the charges? Because I've had in another case where a prosecutor stated at 3 proceedings away from the arraignment, she stated that after reviewing the video.
So, sir, I'm going to take your response as being non-responsive, which is
well, I object to that.
Do with being guilty or not guilty. So I'm going to enter a plea of not guilty for you.
I object to that. I object to that.
Okay, then are you guilty or not guilty? Or standing mute? Those are the 3 things we got going on right now.
Well, I first have to clarify. You did say that I was
presuming to clarify anything, sir. I'm being very fair with you, and right now you're basically splitting legal hairs. Right now, the only thing that I have jurisdiction over is doing arraignment. Nothing more can happen in this case until the arraignment happens. And the arraignment is whether or not you plead guilty or not guilty. And if you're unresponsive to that question, then I'm going to enter a plea of not guilty for you so that I can protect your constitutional rights, because a lot of people don't know that they should. So that's why I enter a plea of not guilty for people who don't really know how to answer the question. So that way they're not getting, no one's going to be bamboozled or said that, well, you said guilty and you didn't know what was going on. I don't want that to happen. I say that you're either going to plead guilty, not guilty. If someone is unresponsive to that question, then I automatically just enter a plea of not guilty for them so that they can preserve all of their rights to a trial and everything else without having been forced to be pleading guilty. So by you saying everything else, that's all well and good, but it's not the time and place for it. See, that's the problem is there's a time and place for everything in the matter of procedures of courts. And when you just start trying to jump the gun and go right from 0 to 60, that's not how it works. There's a stepping process, and everything has to go in that process. And the process today is an arraignment. It's just an arraignment where I'm telling the individual who is alleged to be a defendant what the allegations are. And the allegation is that you violated a city ordinance, and that city ordinance is basically one commonly known as interfering with the police authority. So that's it, and letting you know what the charge is, and letting you know what the penalty for it is. And I've already stated. So again, I'm going to ask you, guilty or not guilty?
Well, I certainly appreciate the explanation. It seemed like you were getting a little angry. I don't know. I mean,
I'm not getting angry, sir. But I'm literally stating that this isn't this. Nobody's trying to bamboozle you or anything like that. I don't know what happened in some other court, and everything that you want to do, you can still do. I just need to know if you're pleading guilty or not guilty. And if you're not answering that question, then I'll enter a plea of not guilty for you so that it preserves all of your constitutional rights and the case still moves forward.
Right. You said we're interested in preserving my constitutional rights, correct?
That is correct. That is correct.
And then one of those.
What I'm saying is everything that you're saying can be used against you. If you think that you have a motion to dismiss, that's something that you can do, but that's when the case is already going to the next stage, which is
well, like I said,
of not guilty for you.
Well, like I said, I would just prefer to be left alone and not have to come back at all. And then if we're not going to do that, then I definitely like to have fair and meaningful hearings. And my concern is we've got a police officer and we've got a prosecutor. Both are state actors, and they're trying to bring charges against me. And I just want to know, because you are a judge and you are another state actor, am I going to get a fair and meaningful hearing here?
And I'm telling you that I keep right here. Hang on 1 second. Right,
and
copy of my Sir, please, I have not cut you off at any point. Please don't cut me off. This is a copy of my oath of office. And why do I keep it here? Because it constantly reminds me that what am I going to do? I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office. So I take that very seriously. My son serves in the Marines. He takes his duty to uphold the Constitution seriously. So if you are implying that I am not going to uphold the Constitution, or that I am going to take an oath and not be true to my oath, then I take offense to it. So if you sense any sort of anger, there's no anger. The only thing I'm telling you is that you are implying that I somehow am an oath breaker, and I am not.
Well, I didn't. I didn't.
That's exactly what. I swore an oath to the Constitution that I put my hand on the Bible and swore to, and I'm telling you, I don't break my oath.
Okay,
So
would you agree
that
that?
implying that you're not going to get a fair hearing? That's my job, is to make sure
Well, I would-
that fairness happens, that due process happens. And so
Well, I do-
so I'm asking you, just as a matter of course, because this is the stage that we're at, is an arraignment. Are you pleading guilty or not guilty?
Well, you just
Or if
said.
you don't, or if you're not responding to that question, I'm going to enter a plea of not guilty on your behalf, and I'll find you standing mute to the question.
Well, I object to anybody making a plea on my behalf, and I just wanted.
I'm not making a plea. I'm just finding you. I'm just entering. I'm just saying that that you are right now presumed not to be guilty, because that's just your constitutional right to be presumed not guilty.
And then that means that,
your constitutional right. I'm not entering a plea for you. I'm just listing you as somebody who is right now not guilty, because the Constitution says you are to be presumed not guilty until proven guilty beyond a reasonable doubt. So I'm not entering a plea for you. I am just merely stating that this individual is to be treated as someone who is not guilty.
okay, and then so if I'm presumed innocent of all the elements of the charge, correct?
No, you are presumed innocent until proven guilty, and you haven't had
Right.
a trial yet. That's your other constitutional right. So if you'd
Well,
like to
yeah.
set this for a trial, we can set this for a trial.
Well, we just said that I'm presumed innocent until proven guilty, and then my question was, am I presumed innocent of all the elements of the charge? And I didn't get an answer to that, because that's a yes or no.
Well, first off, I don't need to answer questions, and nor am I going to give legal advice, because that would be more legal advice that you would talk about with your attorney. And when I'm wearing the robes, I can't give legal advice to either side. I'm more like a referee. I can throw a penalty flag, I can call a whistle for a violation of a rule that I see one side doing or the other side doing, but I can't coach either team.
Well, I certainly appreciate you being fair. Yeah, because
So the answer to your question is I can't answer your question, because that would then be giving you legal advice, and I'm not allowed to give either side legal advice.
okay, because in this particular case, there are crimes that occurred, but the crimes that occurred were the people that put their hands on somebody that had no desire to be having somebody put their hands on them, and then binding them, and then placing them in the back of a gang mobile, and then taking them to a cage. That's the victim in this case. And the victim,
Okay,
if the victim is going to be the city of Taylor, and it's going to be presided over by a judge that is paid by the city of Taylor, with a police officer that's bringing the charges with the help of an attorney, and then they don't know what 241 or section 241 title 18 conspiracy to violate my rights, then I have serious concerns for the fairness and the meaningfulness of these proceedings. And I think that's very reasonable.
I am a judge of the 23rd District Court of the state of Michigan. It's located in the city of Taylor, but I am not. I don't work for the city of Taylor.
But do you see do you see my concern for my safety?
No, I absolutely. Except for the fact is, I'm presiding over the whole case, and I'm going to make sure everybody has due process. Everybody has the same fairness to bring their case, and to make sure that they can cross-examine witnesses and make sure everything is recorded by my recorder, who also has sworn an oath, and I find her to never have broken her oath either. And so I'm just telling you, I'm going to be doing my job, and my job is to defend the Constitution, and I will be doing so. So as of today, it was set for arraignment. I have entered a not guilty as to the charges against you, And right now I can do one of two things. One, I can set this up for a pretrial. The pretrial is something that I always afford the parties where they can talk to one another. If they want to work something out, I have no problem with the constitutional right to enter into contracts and to do things like that. Or I can just set it for jury trial or bench trial right now. If you want to forego any of that and say, look, I really have nothing to discuss with them, I'll just like to go to trial. So would you like to meet with the prosecutor? Well, in which case I will set this up for a settlement conference date where the two of you can discuss the matter. Or I can just set this for a jury trial or bench trial right now.
Well, I mean, I do have a couple objections to that because I'm being labeled and called the defendant here. And what I'd like to be called is the victim. And what I'd like to do is if this is a fair proceeding, then that prosecutor, as long as we're going around and throwing out suspicions and alleging crimes, I'm going to allege them of the crime of the Department of Justice, Section 241, 242, Title 18, which is deprivation of rights under color of law. And I take serious issue with people acting like criminals.
Okay, so what I'm saying is this. One, I don't have jurisdiction to take your case. Two, you're citing to federal law. Three, you would have to file that in the federal court. And, and all of those things are available to you. You have the right to do so and have the proper court, determine that. All right. So what I'm saying is this is a city ordinance, and I have jurisdiction over state cases and over city cases, misdemeanors, and I don't have. And what you're stating, I don't have the jurisdiction to hear. That doesn't mean that you can't bring that case in the proper court. All I'm saying is from now on, I'm just going to refer to you as Mr. Lanto. If you prefer not to be referred to as the defendant, then I'll refer to you as Mr. Lanto. The prosecutor is Mr. Dave Greco, and I'll refer to him as Mr. Greco. And that way, everyone will just refer to one another in their generally names. But what I'm asking you right now is, would you like me to set this for a settlement conference at a later date, or would you like to set this for a bench or jury trial?
Well, I'm willing to forego any intention of criminal charges against the prosecutor if they're willing to just dismiss this now and leave me alone.
So here's the thing: is I'm going to give everybody the opportunity to look at the case and think about it, and not have to. I made sure that you didn't have to take a guilty plea right off the cuff without having to think about it. So I'll set this for a settlement conference. And everyone can come back at that settlement conference. And if there's if there's a resolution, then there's a resolution. If there's not a resolution, then I'll ask if you want a bench trial or jury trial, because that's your constitutional right, and I just need to know which one you're choosing. So, all right.
Outstanding, because I'd like to talk to this prosecutor who I suspect is a criminal at this time, and I would like to.
First off, I'm going to caution you, Mr. Lanto. I'm going to caution you, and I'm going to caution you once. And the next time it happens, I will hold you in contempt, because I will hold anybody in contempt. I do not run a Jerry Springer show. I do not run a Jerry Springer show where the litigants are going to use words and things and call each other names. If you're going to refer, I'm not referring to you as a defendant. I rightfully could. Anybody who has charges brought against them is for a moment known as a defendant. If you look at the dictionary and look up defendant, that's what it says. But you prefer not to be called a defendant, and I acknowledge that, and I'm going to call you Mr. Lanto. You are not.
Sure. Thank you.
You are not, and I repeat, not until you prove otherwise in a court of law beyond a reasonable doubt. You are not to call any other litigant a criminal.
Sure. I've been alleged to be a criminal.
I will make sure that the proper respect is given to you. I'm going to ask the same of you. So you will refer to Mr. Greco as either Mr. Greco or as the prosecutor. But you're not going to call any other litigant or any other witness or anybody else a criminal unless they actually have a criminal record or they have been proven to be a criminal in a court of law by a jury of their peers.
Yeah, and for the record, I called him a suspected criminal. Well, I'm very careful with my words.
Again, you're splitting hairs, and I'm just telling you right now, I'm giving you one heads up. And I don't allow any kind of Jerry type Jerry Springer stuff where there's going to be finger pointing, chair throwing, and name calling.
Well, I did do a cop watch karaoke, which is probably what led up. Which is probably what led up.
All right, so I'm gonna set this for a settlement conference. All of your contact information is correct, so I can make sure that due process is afforded under the Constitution, and I'm mailing, notices out to the proper, spot, and that's the Cloverdale address.
No, and at this time, I don't feel safe giving an address, but I'll give you a phone number and email address that I can be contacted by because I do want to participate in the settlement conference.
Well, right, but I also need to, I'm required by law to mail it out to your last known address. So if this address is something that you will still receive, all I'm saying is I already have an address. I don't.
Yeah, no,
is it still current? Is it still
in the
current?
in the activism that I do, it's important to stay on the move because I have people that try to retaliate against me and do violent things to me. So I prefer not
Well,
to.
then that's up to you. That's up to you to go to the, it is incumbent upon you to go to the post office and make sure that they have your forwarding address. I'm gonna mail, my clerk is gonna mail it out to the Cloverdale address. And if you didn't put a forwarding on there, well, that's between you and the post office. We don't send out emails. We don't send out emails as notice, and we don't make phone calls to let people know when the notice is. We use the mail system because that's the only thing that's tangible and can actually be proven. Why? Because you can see that you put something in the mail. You can actually see that it's been in the mail because it's posted. So
Yeah, is it going to be certified? Because that's the only way really to prove that somebody got it.
no, it's not, and we don't have to send it by certified mail under the court rule. And the court rule has already been ruled to be part of the Constitution, and it's already been ruled as being constitutionally proper under due process of the Constitution. So I'm going to mail it to your last known address. If you have some sort of change of address, that's between you and the postal service. All right. So we're going to set this for a separate conference date. It'll be sometime in the new year, sometime in January, and we'll see everybody then.
Okay, I certainly appreciate you being fair.
That's what I swore to do. That's what I always do. Have a good day.
Thank you.
Hi, Mr. Lanto.
Hello?
Hi, how are you?
Well, I'd be doing better if it wasn't for the implied threat of violence of the state.
Okay. So you're here for a settlement conference today. Was your intention, I'm sorry?
I'm here under threats and duress and coercion.
Okay, that's something you'll have to address with the court.
They're aware.
Okay. So is your intent today to set this for a trial? You don't want to plead on the case?
Well, my intent would be to have the prosecutor dismiss this.
Okay, I'm not going to dismiss the charge.
You do have that option, though, right?
That it is an option. It's not something I'm going to do.
So you have the option to dismiss this, and you're not going to.
That is correct.
So why would you continue pursuing this?
So your option is to set it for a trial then. Would you like a trial by judge or jury?
Well, you're giving me false options because that's not the only option. You have the option to dismiss this right now.
Okay, so Mr. Lanto, I'm going to move you into the main session with the judge, and you can let him know whether you would like a trial by judge or jury.
And just for the records, just so you know,
Mr. Lanto, there is no record. I'm going to.
Hi, Ms. Manarino, Mr. Lanto. Today's the date and time set for a settlement conference, giving you, the two of you, the opportunity to discuss the matter. If you guys work out any kind of resolution, that's fine. If not, we're just going to proceed to trial. So, Ms. Manarino, was there any resolution today?
No, Your Honor.
All right. Then, Mr. Lanto, you'll be receiving your notification for the trial date.
well, objection. I just want to make sure, last time I was here, we discussed the issue of jurisdiction. You gave me a charging document. And on that charging document, if I had you in federal court on a stand in federal court and I asked you to highlight the word jurisdiction, what would you highlight?
So you'll be getting the notice for the hearing for the trial date in the mail. Have a good day.
Okay,
Thank you, Your Honor.
Matter of People versus Joshua Lanto. Mr. Lanto, can you hear me?
I can hear you.
Okay, counsel, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
What? This is what he's, yeah, he came out and went back in.
Okay, Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't, that's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get discovery. It's not the
Well, the first thing I
prosecutor.
want.
You
Okay,
want
the
a
first thing I
trial
request-
today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they sent me to the Oakland County jail.
Mr. Lanto, I'm not gonna produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial today?
Well, let's see what the discovery evidence has to say. But first, if they could, very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney, okay? I'm going to adjourn this matter on his motion for 30 days.
Did you
or
just
so.
say? Can you?
I'm
clarify
going to
something
send
for me?
this to
Did
the
you just-
assignment clerk, Mr. Lanto, you're not listening. See, that's why you get in trouble, because you like to talk and you think you know it all and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully
Well,
your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No, you're all
It
set.
seems like
You
you were
leave the
getting
meeting.
angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will
Well, and
send
I
you a
just
notice.
Well, I just want the record to show I've asked these same questions in several courts, and nobody has said I'm talking crazy.
Oh, yeah.
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And
That's
then
why
number
we're
two,
asking for discovery.
okay, and then the proof of jurisdiction is going to be in there? Is that, I'm asking a simple logical question. It's either yes or no, the proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
Well,
can I put on there that he's in person? I'm going to indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
well, I feel like
Exactly.
I'd be in danger if I came there. I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
will
thing I
you
could
watch
ever
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me? And then you said I'm talking crazy.
No, you got it
Did I
reversed.
just recall what was said on the record? Did I just recall that correctly?
You said no, you said it in reverse. I said first that you're talking some crazy talk. Then I said, I'm gonna adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days. People versus William Vaughn. Mr. Vaughn here.
Hey guys, KFR back again once again. So today we have an update. I just got done with my live stream for walking to go get the kids. Broken System, Broken Trust tried to crash Judge Slavin's live stream today. A channel called No Justice showed up in my chat, said he had the video. So here we are. We're going to go through the video. The first bit is just no audio. So I'm going to cut to when Josh actually starts talking and tries to defend his dipshittery. Hopefully you guys enjoy the video.
Hi,
Hello.
good morning. I think the audio kicked in. What's your name, sir?
My name is Joshua Lanto.
All right, Mr. Lanto, I don't see you on the docket today.
Oh, I was on the docket.
I think we have it set for as a holding date because you have a trial coming up, right?
Well, I don't know. I mean, there's been a bunch of procedural stuff that I have questions on because we kind of, at the arraignment phase, we never really clarified the cause and nature of the charges. And then,
We did. That was clarified quite clearly.
well, I'm just letting you know because I have it recorded. You know, like everybody makes recordings of our court dates, and on the court date, we got
Right.
there were technical issues, right? Do you
Not
remember
that I'm aware of.
that? There were technical issues and everybody disconnected. And
All right, guys, so just for our brains at this point, we're going to jump back a month. And we're going to cover just the tad bit of the very end of his hearing, where the judge tells him what he needs to tell him, says, hey, you'll be getting this in the mail. Bye. There's no technical difficulties. It was over.
So you'll be getting the notice for the hearing for the trial date in the mail. Have a good day.
Thank you, Your Honor.
So yes, you heard it right there. Yeah, it'll be in the mail, Josh. Bye. And then they disconnected him from the stream because he no longer belonged there. It is what it is. Also, the whole, well, we didn't go over the cause and nature of my charges. It's 3 cases of interference. Show up for your jury trial on the 12th. Eat a dick, Josh.
then it went. So I never was formally arraigned.
You were. So, but I had to, so your case, you're gonna get notice in the mail for when your trial date is. And that's gonna be with Judge Shackelford, because I did have to recuse myself because you had made threats against me. And I didn't feel comfortable with you being in my presence. The
Well, just to
case
clarify,
you'll be getting notice of when your case will be heard. All right.
Well, just to clarify, there were no threats made on the record.
No, Josh, you're right. They weren't made on the record. They were made in my premiere, and for some reason you thought the judge wasn't going to find out. The police weren't going to find out. The courthouse wasn't going to find out. You're an idiot.
So, all right, no, not on the record. You did so on YouTube, and so you're gonna.
I say I'm going to throw truth bombs.
Listen, you put pictures of bombs on me, and the judge is going to find out when things go off or whatever. So you know what? If you want to make threats against me, listen, sir, you would never be able to handle a threat against me. I'm just telling you. Just telling you. So goodbye. Goodbye.
You're believing what?
Bye. So when people make threats against you, I'm just going to tell you right now, and anybody else who's watching out there, I don't take threats very kindly. And you know what? I take them very seriously. And you know what? As a man, as a free man, as a man who is an American, I know what my rights are. And I exercise my rights. Freedom of speech, that's one of them. I like freedom of speech. Freedom of assembly. I like to hang out with people who I like to hang out with. Good people. Good, strong people who are, salt of the earth. People like Mike Tinney. Good friend of mine. I also exercise my Second Amendment right. And I'm well aware how to do so. So, I highly suggest you don't make threats against me. Because I do have a right to defend myself. Everybody out there watching, have a great rest of your day. Hey, Judge. God bless you.
So there you have it, guys. Josh made threats against the court. Judge Slavin is clearly about that life. Don't mess with Judge Slavin. Obviously, if you make a threat, people are going to report it. Everyone's going to find out, especially if you're a garbage piece of shit woman beater. Sorry, Josh, those are the facts. See you on the 12th of next month. Hopefully I get an early birthday present. You're found guilty. Again, juries tend not to like frauditors, tend not to like sovereign citizens because they're assholes. They don't belong in regular society. Good luck. Peace.